page 41, and it has to do with so-called formula clauses. This problem emanates from the fact that, as you all know, in this year, there is no federal estate tax and no federal generation certificate tax. There is a New York and most states kept their estate taxes. Our threshold is still $1 million, although they took a little machinations that I think a statute to make that clear. But what this statute that is in the materials was drafted to accomplish was for people who had wills that were executed prior to 2010, but had clauses in them which assumed that there would be an estate tax regime, federal estate tax regime in 2010, and did not get around to changing them when Congress unexpectedly let there be no estate tax in 2010. It is basically a provision, statutory provision that construes formulas in wills that have been not revised by the draftsman himself or herself. And I picked one of them here. This is the one that's most often spoken about, one in which the formula leaves to a credit shelter trust the amount that could pass, the maximum amount that could pass free of federal estate tax. And prior to 2010, that amount, the maximum amount, would have been $3,500,000 because that was the federal exemption amount or unified credit amount. And but in 2010, the maximum amount is infinite because there is no state tax. And so the fear that drove this statute was that provisions like this in a will would end up leaving, if the estate, as in my example, is $5 million, would end up leaving the entire $5 million to the credit shelter trust, and nothing in the residuary clause outright would go to the surviving spouse. And this statute is designed to say, no, that really was a mistake not to redraft that, or a mistake to assume that Congress would be respectable and do something about it, and therefore we're going to presume that the statute, that the will clause means what it was intended to mean, which was that it would only be at the most $3,500,000. Now, and there's a similar provision with respect to the unlimited GST transfer. As I was researching this, in fact, very serendipitously, I just got in the mail yesterday this latest issue of the Trust and Estates magazine, and there's a very, very good article by Sharon Klein called "When the Dust Settles," and she gets into a lot of these 2010 issues. This is one of them, and she reviews these statutes, because statutes like this have been passed in many jurisdictions. But as she pointed out, it kind of dawned on me, and I didn't know where I was going to go with it. And I read this, and I said, "Oh, she's thinking that way too in some legislatures." That in fact, that in a case like this, it might be that it would be better, because you notice in my credit shelter that I have here, the widow is the life beneficiary of the income, and the kids are the remainder men. I don't put anything else in there, like things that could, ascertainable standards and stuff like that you could doctor up your credit shelter trust with. But it may be that if people crunch the numbers after the dust settled, they would prefer that the literal language of the will actually pass the property to the credit shelter trust, and nothing go under the residuary clause outright. In other words, the statute might be making a presumption that is not 100% true in all cases. Because even though that it might be that in that situation you might end up paying some state taxes because you're over the $1 million threshold, for example, that it might be that people would say, yeah, but you know, I think what Congress is going to do is they're going to come back in and they're not going to give us $3,500,000, they're not going to give us $5 million. As it is right now in 2011, it goes back to $600,000. And if I can get this property out of my estate at this point, and it's not going to be in my wife's estate because it's not going to be in there because it's in the credit shelter trust, then I would just as soon let her go. Look at, she's getting everything under this credit shelter anyway, all the income, she can get the corpus if she needs it, and so there are some statutes in some jurisdictions, not ours, but in some jurisdictions that, like Delaware, it allows the executor to opt out, or an interested party to opt out of this statute. There are others like Wisconsin that basically say if you have a credit shelter trust like the one I have, and I had it by accident, frankly, because I hadn't read the Wisconsin statutes, and I haven't, still haven't read it, I just read this article, that say basically doesn't apply. Because in that type of situation, the person would probably like to have it go literally the way the will says. So the name of the game, of course, would be is that, you know, none of this is left to chance. The person's will who's drafted like this is eyeball and fixed in accordance with what the desires, the proper desires of the testator is. Okay, I think that's that for that. Okay. There's one other aspect of the statute. This statute does allow a proceeding to be brought by the executor. That's kind of our answer to the problem I just raised. Our answer, although frankly, I know because I was kind of involved in the drafting, I take some blame of this statute, and I never thought of this problem. That it does allow the executor to go in and say, that's not really what he meant. That's not really what he meant. And maybe you could bring in, these kinds of consideration to say, let it go the way it was. Let it go the way it was. So you might be able to get a sympathetic surrogate in a given case to read it the way you want it to be read. But it's not really spelled out the way some of these others. It probably should go back to the drawing boards. But all right, that's hypothetical 6. Hypothetical 7 has to deal with a statute which did not get passed. And I'd like to put this in perspective. It seems like 1,000 years ago, I was on the EPTL Advisory Committee, and the first thing that the EPTL Advisory Committee did, to the consternation of about 98% of people in the state bar, was to get the legislature to eliminate the so-called elective share trust, such that if a person had, John is still giving me thumbs down on it, such that if a person had $3 million in his estate, he could give his surviving spouse 10 grand, or they could let it go all the way up to 25 grand at one point, and then put the other third of it in a trust to pay the income to her for life, remains to the children, just like a Q-tip. And that satisfied her right of election. She had no right of election. And of course, as you know now, you can't do that. You can't do that. Now you have to give her a third outright. So she has to get $1 million, not a life income on $1 million. Has to get $1 million. And the whole point was disposition. And the whole purpose of the statute was to simulate what would have happened if these people had divorced. And there'd been equitable distribution. And the whole notion is, you know, the economic partnership notion of marriage as opposed to the support notion. And so that statute's been on the books since 1992. Well, almost immediately thereafter, those people who were consternation, you're concerned, If you're a consternation, yes, you're concerned. Those people in the state bar that were concerned, they said, well, we know the way to do this. What you do is get a waiver. You get a waiver of election. So the EPL Advisory Committee in 1993 promulgated the statute that said, fine, that's fine. But you know something? You're not going to have one of these things unless you disclose your assets. You can't go getting the widow to waive her right of election if you've got $3 million and she thinks you only have $300,000. So you got to tell her you've got $3 million, whether it's before the marriage or after the marriage. You got to do that. That's what this statute that did not get passed. And this was offered in 1993, and it's been offered almost ever since that time, and never got anywhere. Why? Because it wasn't until last year that the Democrats had something to do with the Assembly. And once the Democrats took over the Assembly, they thought this was a good statute, and so it got passed last year. And now, of course, out of the woodwork comes those concerned people from the state bar. There is a word, concerned. And they said, it passed both houses of the legislature, went to the governor, and they got to the governor, and you've got the governor's veto message in your material. And they basically, I say, and I'm prejudiced, because I was one of the people involved in this original statute, they sold the governor a bill of goods. And I said that, this isn't a polemic. It's not only a polemic. But the reason I say this is because what they said to the governor, what the governor brought, was that this statute substitutes for clear common law a very subjective, vague standard, fair and reasonable, as opposed to what we have now. And in the course of doing it, I would suggest to you what they did was they misstated what the current law is. Because the current law basically is the Greif case. G-R-E-I-F-F, which I think I've cited to you here. Yes, 92, matter of Greif. And if you read the Greif case, I think you will come to the same conclusion that Surrogate Radigan came to it when he was still a surrogate and he had to deal with one of these waivers. And he's opened his opinion saying there was a cottage industry that grew up in ancient Greece called soothsayers, and their job was to divine what it was that the Oracle at Delphi said when the Oracle of Delphi made his prophecies. And he said, and if you read the Greif case, you will think that you're in the same position as one of these soothsayers. Judge Bellicosa wrote the Greif case, and he talked them back and forth, and basically said that everything in this situation as to whether the waiver is going to be valid, because that's what Greif case was, the waiver of the right of election, depends upon a particularized inquiry into whether or not there is equality between the parties. If there is not, then unlike what they said to the governor, the burden shifts. It is no longer on the person trying to upset the waiver. It is on the person who got the waiver signed to show that it was fair, reasonable, and not the product of overreaching. And so what you have now is the continuation of the Greif case. Aside from the fact that that's probably not the law in most of the states, that the law in most of the states is much closer to the statute which didn't get passed, it would seem to me that at least as a matter of advising people, as lawyers, aside from what you think about as fairness, as lawyers, you'd be much better off with a statute that says that if you're going to get away with the right of election, you've got to do a fair and reasonable disclosure of these things. You've got to do that in matrimonial cases by statute. One of the things they said to the governor is that it's done all the time in antenuptial cases. Postnuptial cases, they say, is the problem. But if it's done in antenuptial cases, why can't it be done in postnuptial cases? And I think, frankly, this is where my bias will show. I think it all goes back to the fact that there are many lawyers in this area, and this is basically, in my opinion, this is a man-woman problem, but that basically in this area, many of the lawyers represent men with a lot of money, and they want as another arrow in their quiver this ability to write the right of election off by getting a waiver since the 1903 statute. But that's where it is, and so you still, in this area, you begin with gripe. If the statute's going back in again next year, and so we'll be in for about the 90th time, and maybe when it passes this time, Governor Palladino will sign. Hypothetical 8, exempt property. This statute, section 531 of the EPTL, is a statute that, when I teach this statute, and little did I know that many practitioners didn't even know about it. That it's a statute that's, even though it's known about, it's kind of ignored, and ignored at the administrative level, as well as at the drafting level. But it's there, and what it basically says, what it was there to do, it's called exempt property. And the reason it's called exempt property is because the property that's listed in the statute, things like the automobile, the household utensils, the clothing of the decedent, those things are exempt from creditors. They are set off, and the creditors cannot get at them. The notion, one of the funny parts about this is it has domestic animals, and now it's changed also to farm animals, but also they have food for 60 days. That's exempt for creditors. When one of your partners, Sharon and John, Arthur Sherwood, did a research on this way back, he found out originally that it also included food for 60 days for the widow. It doesn't include that anymore, but includes if she can eat the dog food, 60 days of. But at any rate, the offshoot of this is also not thought of very often, which is that in addition to being, and its main purpose is to exempt these things from creditors, it makes this property not part of the probate estate. That is to say, it isn't part of the intestacy property. It does not go under the property for the right of election, and you cannot dispose of it in your will. So that in my hypothetical, the president's book, President Kennedy's book, Profiles and Courage, is a book. And if that book is within the statute, then the fact that he left the book, that W left the book to Sue, makes no difference. The book belongs to H under this statute. It's set off for the surviving spouse or for children under 21 if there is no surviving spouse. That is just children, not grandchildren. Children under 21 if there is no surviving spouse. But the statute also has monetary limits. For example, it has about 2 or 3 categories, and the book is in a category with other household goods that has a limit of $2,500. So that if this book is worth more than $2,500, it's not within that limit, and therefore it is not exempt property. Now, the statute does give the widow or the widower the chance to buy that property if it's over the monetary limits by coming up with the difference. So if the property of this book was worth, say, $30,000, the husband could buy that book by paying into the estate the difference between $2,500 and the value of the book. I'm forgetting about the clothing, etc. That has to be filtered in as well. But other than that, it cannot be transferred by will. The second item that's in this hypothetical is jewelry. And jewelry, for the first time, is mentioned in this statute, but it's mentioned in a very peculiar way. It says that jewelry is exempt property unless it's disposed of by will. Now, what the heck does that mean? Best I can do with it means that if you want to leave your jewelry to somebody, unlike the book, you can leave it you can leave the jewelry to Nora within again the monetary limits. of that statute. But if you don't, if you do leave it to Nora, not to Sue, if you do leave it to Sue as this W has, then literally it's no longer exempt property. So that when I say in my second part of my hypo, supposedly the estate is insolvent, that seems to mean the jewelry now can be reached by creditors because it's been left by will, and that makes it non-exempt property. That may not be what they intended, but that is what the statute seems to say. The most important part of this statute is that it makes as exempt property 25, it used to be 15, but now it's $25,000 in cash. And cash can be in terms of, it says cash, checks, savings accounts, CDs, money market accounts. It does not include, as it used to, stocks and bonds, because that used to be included as other personal property. But now stocks are not, so you don't have it, that's just not included at all in any of this exempt property. But there's a very, I was talking to John at the break about it, and I just throw this out to you. It says that this cash is to be, this $25,000 in cash is to be reduced by the amount by which these other items, like the book, or the jewelry, are in excess of their statutory monetary limit. So take my example again of $30,000, a $30,000 fair market value for President Kennedy's book. Yeah, that's $27,500 over the amount of that particular category. Does that mean that the $25,000 that's sitting in that bank account now is reduced by, it seems to, it's reduced by now $27,500, and therefore the surviving spouse is not entitled to any of that cash? I think that's true, but at least in that situation, that surviving spouse gets the book. But the way I read the statute, and John says you can't read the statute like that because it's crazy to read it like that.
Actually, it uses
The way I read the statute like that is that she loses even though she doesn't get the book.
but it uses the word acquired.
Excuse me?
In paragraph 6, it uses the word acquired, so the surviving spouse would have to acquire the book. And if she, under the earlier section, she wouldn't be able to acquire it because it was over the amount. So therefore,
part that deals with,
the reduction, it reduced by the excess amount of any, if any, of acquired items. She didn't acquire the book because the book is worth more than $2,500, so we couldn't reduce it.
acquired, so that's right, okay, fine. So in other words, she gets the book.
No, she does not get the book. She gets it because she doesn't get the book because it doesn't fit within
Right.
$2,500. And since
So she doesn't get the book.
then it doesn't reduce under 6.
And also, if she wanted the book by paying for it, it wouldn't reduce it.
Wouldn't reduce it either.
Wouldn't reduce it either, okay? You got all that? Right, okay, yes, all right.
I'm not sure it's right. But
Right, okay. The one thing though that I think we would agree on, and I would think of getting back, there's two aspects of this kind of, I don't want to spend too much time on it, but in terms of everyday administration, it could present some nightmares because that $25,000 again in cash is reduced by the overage of all of these other types of categories. Does that mean, that's a brand new provision, by the way, that reduction was never there before. And does that mean therefore we gotta have appraisals of all of this stuff to see whether it's within, in order to see how much of that 25, it seems to me that, and that's crazy. That's crazy. And then the last thing that seems to be problematic is the very last part of the statute that says, just very blanketly says, the surrogate shall have the right, power, to issue, quote, documentation, unquote, to facilitate the operation of this statute. What the heck does that mean? And what kind of documentation? And who's going to pay for that? And that's the kind of thing that makes people like Lydia tear their hair out.
62 different counties, you can have 62 different
A different kind, exactly.
But I think, you know, when I read this, Professor, it's taking simple math, you know, you set off the car, you set this off, and I had no problem. And it's put it into a complicated formula. So how can you give out any documentation?
Right, exactly.
Without an accounting?
Right.
And that's at the end. It doesn't make sense.
Right. I think it's going to have to go back to the drawing board. I mean, the statute was designed primarily to modernize, to bring the amount up, the total amount up from 56,000 to about 92,500, and also to bring in new things like DVDs are in there now, and they weren't in there before. So that was the purpose, but I think they created problems that are going to have to be straightened out. Roman, yes.
I think on that issue of the surrogate authorizing documents, the concern, I know one of the members of the subcommittee that worked on it. The concern was that perhaps institutions today might not just do things automatically, and you can't go to a bank and say, well, it's under the law. You've got, sometimes you need to have something more, which may be an order from the court saying, yes, this is
exempt property.
Therefore, give it to this person.
Right, right.
And who would pay for that, I'm going to assume would be the person who would be entitled to it.
Right, I think that's right. I think
That's why
in other words, this doesn't jump out to a bank.
Right.
Right, and you just say, this much is exempt property, but it does require you to do all of the, as Lydia said, it requires you to do all of the mathematical calculations that the statute does, right? Okay. All right, Roman numeral 9. We're supposed to break here at 4:15. So I'm going to try to get through. I think we should be able to. This statute actually came from the OCA committee, Surrogates Practice Committee. Before this, it has to do with the inheritance by so-called non-marital children, non-marital issue. More specifically, it deals really with the impact of DNA. Prior to this amendment, a person could inherit in intestacy as a non-marital child if there were certain types of formal activities by the putative father. It could be, for example, a judicial finding of paternity. There could be a formal acknowledgement that was signed and filed in the so-called putative father registry. And I think there actually were some people that actually did that. The registry was in Albany, but I think people actually did that. But the guts of the statute was administered by subdivision C and D of 412 small a. And in D, you could prove that you were a child, even though non-marital. You were a child if you got a blood genetic marker test plus some other evidence, all of which amounted to clear and convincing evidence. The problem was with D was that the DNA test could only be administered, had to have been administered before the person died. If it was not administered, the cases said the statute would not allow it. So D was kind of a useless provision. C then got most of the traffic, capital C. The problem with C is that it was a two-edged requirement. You had to show not only that there was clear and convincing evidence, which you could show by DNA testing done either before or after the decedent died, but you also had to show acknowledgement. So it wasn't enough for there to be open and notorious acknowledgement, and there wasn't enough for there to be clear and convincing evidence through DNA testing. You had to have both. And then, of course, the courts get into a big fight as to which came first. Could you order DNA testing if there was no acknowledgement? And get the DNA testing and then try the case as to whether or not, if there wasn't clear acknowledgement. Could you get the DNA testing and then come back to the court and then try the case as to whether there was enough to constitute acknowledgement? or did you have to try the case on acknowledgement first before asking for the DNA testing? And Surrogate Howe in Erie County went one way. She was affirmed by the 4th Department, in which she said, no, we can order DNA testing first without coming to a finding of acknowledgement. And the 2nd Department said, no, you gotta find out, you gotta go the other way. 2nd Department finally changed its mind and came closer to Judge Howe, and Judge Howe came a little closer to the 2nd Department. And basically the law before the statute was that you, if you had some indication that the person was the child, by something that the person had said, the father had said, then you can order the DNA testing. None of that now, none of that fight is relevant any longer. Because now the statute says there's only one standard, clear and convincing evidence. And therefore, if you have DNA testing that either before or after that provides that clear and convincing evidence, that's enough. And you don't need acknowledgement. Which made some people a little unhappy, because a lot of people think that, you know, since I could cut out my non-marital kid in my will, then I should really, my acknowledgement should have something to do with it. If I don't acknowledge it, maybe DNA shouldn't be enough. But what prevailed was the notion that if you want to cut them out, you write a will. If you don't, then, and if it is your kid, then they entitled to inherit regardless of whether you like it or not. So in my hypothetical here, we have Jane, who can show paternity by the DNA she's going to take, even though there was no acknowledgement, even though the person said, she wasn't my child, because DNA will show that, and that's enough under the statute. The more interesting one, I think, is John, although probably not practically more interesting. For me, it's a little more interesting under the statute, because John the DNA will show he was not the child. But the father treated him as a child. And the statute says that, again, that you can get clear and convincing evidence either by this DNA testing or by some sort of acknowledgement. In other words, acknowledgement plus other factors, if you will, and acknowledgement is relevant. And more importantly, that legislative history that I quoted indicates that it's conceivable a court may determine for policy or equitable reasons, quote unquote, that a father's open and notorious acknowledgement prevails over what? Over the DNA testing, than to the contrary. So it may be that John has a shot. Jane is pretty much in, but John can have a shot. But at least it eliminates all that litigation now. I gave you the legislative history, which gets into all those cases, Morningside and Davis and Paul Rogers. Those things read of historical value only. They're no longer relevant anymore. The second last hypothetical is probably the most important one, and that has to do with pet trusts. And I did a little research and found out more than I wanted to know about sea turtles. And one of the things I found out is that there are various kinds of sea turtles. And that the one that's called a loggerhead sea turtle is the one that has the longest lifespan. And also has a reproductive life of 30 years. And that the average lifespan of the sea turtle is 80 years. And so under the statute before it was amended, this trust could only be set up for a fourth of that poor sea turtle's life, and had to spend for himself or herself for the rest of those 60 years. And now this can last for the life. And you know what's interesting is, and I noticed that who's the chair of the, Gary Friedman, who's the chair of the P&E section this year. And in his latest newsletter, he had the same thought. The 21 years in this statute that's now eliminated, in this pet statute, really came from the rule against perpetuities. Because there is case law before we had a pet statute, trust statute, that said that if you set up one of these trusts and it was The money could be paid for the care of the trust. And it was over 21 years that it violated the rule against perpetuities because it was not an interest that could vest within the 21-year period, because the lives in being could not be animal lives, they had to be human lives. And that's why when they came to put the statute in, they put in 21 years. And now they decided to basically to get rid of the rule against perpetuity. So, what I would say is what the bankers of New York have been trying to do for umpteen years, which they've been able to do around the country in like Delaware and South Dakota, and you name it, get rid of the rule against perpetuities, and they haven't been able to get rid of the rule against perpetuities in New York. The pet owners of New York have been able to do it. The final thing that bring us up to quarter of is a statute that I did not print out for you because it was too long and it would be enormously complicated, but you really should sit down and read the statute as amended and read the amendment, and that's the power of attorney statute. What I did print out for you was the Law Revision Commission report. One of the requirements of the so-called Technical Amendments Act on this power of attorney statute that was enacted in 2009, and the amendment in 2010 required that the Law Revision do a study of the most controversial part of the statute, which is the so-called statutory gifts rider. And that report, which was issued in September, is printed out for you. And it gives you a nice little overview of the statute itself. That's why I gave it to you. And it tells you what the new amendments do basically to it. But I think that one of the things I'd like to focus on, just in the few minutes left that I have, is this statutory gift rider. That's really the practical part of this statute. And you can say what you want about whether it should have been in there. I happen to agree with the philosophy of it. I think it's the same philosophy that gave rise to when you're the executor and you're a lawyer and you have to have them execute a separate under 2307A. You have to have a separate document saying that you've told them that you can get both executors commission and legal fees. That kind of, openness and disclosure is really what this statutory gifts rider is all about. So I agree. I think that the problem with the people have with it is they think it puts on an extra layer of ritual that makes the process that much more burdensome for the client. And I think, reasonable people can differ on that. The one thing that it occurred to me was to the extent to which, and I'd like to throw this out because I've never asked anybody about this. One thing that occurred to me was, do you save anything, or is there any mileage in saying, the hell with that statute? I'm going to do an old-fashioned power of attorney, a common law power of attorney, a so-called non-statutory power of attorney, and therefore I don't have to get into some of the stuff that's in there. But before I ask that question, let me just kind of put it in perspective. The statute covers both statutory and non-statutory. It covers the common law, and it says there are minimum things that you have to do. You still have to, whatever matter what kind of statutory or non-statutory, it has to be signed and acknowledged by the principal, signed and acknowledged by the agent. It has to be it has to be in certain 12-letter type, and if it's going to give gift-giving power, statutory or non-statutory, it has to be signed and acknowledged again it seems, by the testator, but maybe by the principal, maybe on a non-statutory, it only has to be signed and acknowledged once. But it certainly has to be signed and acknowledged twice if it's a statutory one. And there has to be, whether it's statutory or non-statutory, there has to be 2 witnesses to that gifts rider, which allows the attorney to make gifts. The one thing I think that you get a little more flexibility on the non-statutory one is that in the statutory one, if you do a gifts rider, there are 3 more boxes that you have to consider. The first box is the one that says you can give annual exclusion gifts to members of your spouse, your kids, your issue, and your parents. And the second one, and if you just check that, that's the only gift-giving power that the agent has. The second one is you can check a box that says, no, you can give lower or higher than the annual exclusion. You can give it to anybody you want, but you got to check this box if you want that agent to be able to do that. And then the third box is if you want the agent to be able to give gifts to himself or herself. I got to check that. The way I read the statute, you don't have to go through all that box stuff, those 3 boxes, as far as a non-statutory power. But it seems to me the reason they went to a statutory power was so-called short form and allowed the incorporation by reference of all of these powers that an agent has. If you just say real estate transaction, then you go to the statute and then it says, what does real estate transaction mean? And it lines them all up. Whereas I would take it that you'd have to spell all of those things out, but nowadays, who cares? You hit a button and you know, it incorporates by reference on your computer. So let me, with that, and by way of closing, does anybody do non-statutory powers of attorney? John?
Not yet.
Not yet. Yes.
I've only done it for condominium associations. I would not do it for a regular human being client because I'm afraid that it won't be accepted.
Yeah, that's what I was just good. In other words, the statute has, what the references to is that part of the statute puts a burden on, although it says the only thing you can do is get an injunction against them, against banks and other institutions to accept this. And the same provision does not apply to non-statutory powers of attorney. Very good. Well, thank you very much for your attention.
What's your view of the rationale behind having the statutory gifts rider executed contemporaneously with the power itself? That seems to me to be simply a trap for the alert. Somebody is going away on a trip. They sign a power. They come back, and we have some discussion about gifting. We have to re-sign the power. What in God's name was the theory behind having them executed simultaneously?
John, I wasn't there when this was being discussed.
No one has been able to answer.
My guess is that they're saying that it's all part of this ritual. They want the testator to be, the principal to be focusing on the notion of giving powers to somebody else. Remember, you got all that stuff about you don't have to do this. This is very important. But I think you're right. I think there's no reason why. Because there's enough in the gift rider itself. There's enough ritual in the gift rider itself.
I think there's more ritual.
I agree. And I think that might be certain, because they are considering further changes. That might be one that they would be very well considered. Okay. Thank you very much for your attention.